Okay, perfect. Thank you so much. Well, good morning, everybody. Last Saturday, I gave the class regarding mistake. This time, I'm going to give the class again. It's going to be about duress and undue influence, which are vitiating elements in the formation of a contract. Okay. Nowadays, well, and before, courts are reluctant to set aside a contract between parties of unequal bargaining power just based on inequality. However, at the same time, courts will not allow the strong party to push the weak party to extract an agreement. And in certain circumstances, courts will set aside apparent contracts. So law and equity have developed different responses to the use of illegitimate pressure. For instance, courts of equity would set aside a contract where one party had unduly influenced the other one to enter into a transaction. And courts of common law would, under the doctrine of Duress, render a contract voidable where one party has employed illegitimate pressure during the contractual process. I want to apologize. Like, I don't know, I think that I'm having like allergies problems. My voice is a little weird and I'm, sneezing a lot. So I want to apologize in advance. So having said that, let's start with this class. Oh, okay. So do you want me to repeat again what I have said? I'm sorry, I don't. Let me know if you want me to repeat what I have said. Can you hear me? Would you like me to repeat what I have said? I want everybody, like to. Okay. Okay. So just let me know when you want me to repeat one part, and I'll. Okay, I'm going to repeat it. Okay, Jen. Okay. So what I was saying is like this class is going to be about duress and undue influence. These are considered vitiating elements in the formation of a contract. Okay. So what we have said is like courts don't like to set aside contracts where there is like based on inequality, but at the same time, courts will not allow the strong party to push the weak one to get an agreement. So in such circumstances, the court will set aside apparent contracts. Okay, and the Court of Equity have developed the defense of undue influence, and under this one, the Court of Equity would set aside a contract where one party had unduly influenced the other one to enter into a transaction. And the courts of common law, under the doctrine of duress, would render a contract voidable where one party has employed illegitimate pressure during the contractual process. Okay, so that is what I have said. So I hope like everybody hear well, and like and let me know if there is any problem, and I would be more than happy to repeat it again. Okay, so let's start. In this lecture, we are going. Wait a second, please. Okay. In this lecture, we are going to talk about duress. What is duress? Its effect and form of duress. These forms of duress are like duress to the person, duress to goods, and economic duress. Also, we are going to talk about undue influence, actual undue influence, presumed undue influence, and undue influence and third parties. Okay, let's start with duress. What do you think duress is? What do you understand by duress? Make someone do something under pressure. Yes. Under undue pressure to put another person in a position where they don't truly have a choice. That's a good addition. Yeah, according to the Black's Law Dictionary, duress has been defined as a threat of harm made to compel a person to do something against his or her will or judgment, especially a wrongful threat made on one person to compel a manifestation of seeming assent by another person to a transaction without real volition. So a person who acts under duress does make a choice. In other words, like his act is not automatic. Nevertheless, this choice is one which they have been compelled to make, okay, because of the threat. There is a case where two elements of duress are established. This case is R versus Attorney General for England and Wales. And these two elements of the run of duress are pressure amounting to compulsion of the will of the victim and the illegitimacy of the pressure, okay? What are the effects of duress? When duress is present, the contract is voidable rather than void. So if the weak party is successful in proving that the contract is vitiated by duress, the contract may be rescinded since it is then voidable. The apparent consent of the victimized party is treated as revocable. So the victimized party has the ability to affirm or not to affirm the contract. So if she chooses not to affirm the contract, it is void. The effect of finding that duress renders a contract voidable creates important consequences, okay? The first one is like the party subject to the duress must act promptly to set aside the contract. What do you understand by this? Like, for instance, like if I threat somebody to sign a contract with me, and this person, like, what does this person needs to do according to these consequences, to this consequence? Yes, the person has to sign the contract. Yeah, because of the threat that I have made on that person. But as I mentioned, you know, like this person, he or she must act promptly to set aside the contract. There is a case which is called the Atlantic Baron case. Here, I'm going to give the facts of the case. The defendants agreed to bill a ship for the claimants for a certain price specified in US dollars. After entering the contract, the US dollar was devalued by 10%. So the defendants threatened not to complete unless the claimant paid an additional 10% on the contractually agreed price. The claimants, they had a valuable charter line, so they agreed to pay the additional funds, and they paid without any protest. 8 months after delivery of the ship, the claimants brought an action to recover the additional money paid. What does the court say in this case? That the contract was voidable for Duress because the defendant threatened them not to deliver the ship. However, since the claimants had left it so long in bringing the claim, they had affirmed the contract and lost the right to rescind. Okay? Another consequence is that a third party can acquire good title to goods even though his vendor has acquired those goods pursuant to a contract which was brought about by Duress. Okay? What are the two categories of Duress? What do you think are the two categories of Duress, the forms of Duress? What do you understand by physical Duress? Threat to person. Just to persons, to goods, yes. So it's Duress to person or Duress to goods. And economic Duress, what do you understand by economic Duress? Creating circumstances. We are going to see, like here in physical Duress, like some of you have mentioned, physical Duress, we can see that there are like Duress to the person and Duress to goods. So economic Duress, pressure or financial loss can occur. Yeah, that's correct. That is related to economic Duress. Okay, so let's start with physical Duress, Duress to the person. So Duress to the person occurs when one party to a contract forces another to contract with him through threats of violence. Okay, Professor Ronald Griffin, he puts it very simple. He says, your money or your life. That is Duress to persons. So in these cases, the law will find an apparent contract voidable where Duress is a reason for the contract. The Duress doesn't have to be the reason for the contract, where a party enters into a contract for several reasons, of which the Duress is only one reason. The contract is still voidable. Okay? So there is this case that is here in the slide is the Barton versus Armstrong case. Yes. Can you please mute your microphones so like everybody can hear well? Let me know by chat, by the chat. Thank you so much. But let me know by the chat, like if you cannot hear me well or if you want me to repeat any part of the lecture. Okay? Thank you. So as I was mentioning, Duress to the person occurs when one party to a contract forces the other one to contract with him through threats of violence. Okay, the Professor Ronald Griffin put it like very simple, like physical Duress is like your money or your life. Okay, there is this case, Barton versus Armstrong, where Armstrong threatened to kill Barton if he didn't sign a contract. So the contract was set aside by the court due to duress to the person. No, an innocent party, the weak party, wishing to set aside a contract for duress to the person, needs to prove only that the threat was made and that it was a reason for entry into the contract. The burden of proof then shifts to the other party to prove that the threat had no effect in causing the party to enter into the contract. Okay, so the weak party, the innocent party, so needs to prove that the threat was made and it was the reason why he entered into the contract. Then the burden of proof shifts to the stronger party, and the stronger party needs to prove that the threat had no effect in causing the weak party to enter into the contract. Okay? In these cases, do you think, in these cases of duress to the persons, do you think that the meeting of the minds is met? Okay. Why? Why do you think that there is no meeting of the minds? One party was coerced. Yes, you are right. You know, like in these cases, there is no really manifestation of mutual assent, the meeting of the minds. Rather, what we can say in these cases is like when someone is threatened and agrees to act to avoid physical harm by the strong party, all you truly have is a mirror of the strong party's manifestation of mutual assent, not the manifestation of mutual assent by the weak party, because the weak party has been forced or induced to assent to the terms of the contract. Therefore, the meeting of the minds in truth doesn't exist. Since there is no meeting of the minds, there can be no contract. Okay? Let's talk about now duress to goods. What do you understand by duress to goods? Threatening property. Yeah. Duress to goods may occur where one person threatens to destroy or take the goods of another unless a contract is entered into. Okay? In the case of Skip versus Bill, the facts of this case are a landlord was owed money by the tenant. So the landlord cites goods owned by the tenant and threatened to sell them immediately unless the tenant enter an agreement for repayment of the sums owned. The tenant agreed to the repayment terms, but then sought to have the agreement set aside for duress. What did the court say in this case? The court said duress to goods will not suffice to render a contract voidable. You know, although this case lays down the rule that a contract entered into in persons of a threat to retain goods cannot be set aside, there is a restitutionary rule to the effect that money paid to obtain the release of goods wrongfully detained or to avoid their seizure may be recovered. Okay, so in these cases of the rest to goods, we need to see also like this restitutionary rule. Okay, for instance, in the case Maskell versus Herner, the defendant demanded money from the claimant by way of a toll fee for his market stall. The defendant threatened to seize the claimant's stock and sell it if he didn't pay up. The claimant paid the toll fee for a considerable period of time and then brought an action for money had and received to recover the money paid under duress. The court, in this case, said the claimant was entitled to recover the sums paid in the law of restitution. Okay? Let's talk about now economic duress. Some of you mentioned, like, economic duress involves like where there is one party who has more power in economical terms than the other one. So economic duress occurs where one party uses its superior economic power to force the weaker party into an agreement. In these cases, a contract is voidable if the innocent party can prove that it had no other practical choice but to agree to the contract. But there is like in this area, what is difficult to draw is a line between what is called unacceptable commercial pressures, which amount to economic duress, and acceptable commercial pressures. Okay? I don't know if somebody has read the facts of the case Pao Ong versus Lao Ji Long, or if you want me to tell you the facts. Okay, I'm going to tell you the facts of this case. In this case, the claimant had threatened not to complete the main contract for the purchase of shares unless subsidiary agreements were met, including a warranty and an indemnity. The defendant was very anxious to complete the main contract as there had been a public announcement of the acquisition of shares and didn't want to undermine the public confidence in the company. The defendant could have sued for a specific performance of the agreement, but he thought this would have delayed matters and damaged the company's reputation. The defendant took legal advice on all these matters before agreeing to the warranty and indemnity. The claimant then sought to enforce the warranty, and the defendant sought to have the agreement set aside for economic duress. What the court said in this case, that there was no economic duress. What we can identify in this case, there are like 4 factors that the court identified to consider in assessing whether economic duress was present. So these 4 factors are: did the person claiming to be coerced protest? This is the first one. The second one, did that person have any other available course of action? Was the weak party independently advised? That's the third one. And the fourth one was, after entering into the contract, did they take steps to avoid it? So what can we say in this case of Pao On? Let's see. Did Pao On claiming to be coerced protest during this agreement? According to the facts, no. Yes, PAO didn't protest. Did PAO have any other available course of action besides, like, yes. What was that? PAO could have enforced the contract of sale through a specific performance. So he could have had another venue of redress available to him, but he didn't do it. Okay? Was PAO independently advised? In the facts of the case says that, oh, I'm sorry, it is not PAO, it's the other party, Lao Yulong, is the defendant. In the facts that I summarized, says like because the defendant was so anxious to complete the main contract, he agreed and signed the contract regarding the subsidiary agreement of guarantee and indemnity. So the defendant took legal advice before agreeing to the guarantee and indemnity. So we can say here, like, the defendant took, prior to the claimant, the defendant took legal advice and took no steps to avoid that agreement prior to the claimant seeking to enforce the warranty. So we have seen like these four factors that the court consider in assessing whether or not economic duress is present are met in this case. So that's why the court said no economic duress could be established. It was simply commercial pressure far short of duress. Exactly, it seems he took a commercial decision. He took risk. The court, regarding this topic of economic duress, has held that in order to establish what constitutes economic duress, we need to consider every case. So economic duress was to be considered on a fact-specific basis. So we need to see the facts of the case and then like apply these factors that I have mentioned, so to decide whether or not economic duress has happened. Okay. Also, the court has said that there was no requirement that an unlawful act had been committed. Okay. The court said that when lawful but unethical behavior can be economic duress, so that a contract obtained but that unethical behavior may be voidable. Okay, so the act doesn't need to be unlawful. It can be unlawful but unethical behavior. There is a case, another case, it is called Alec Love Limited versus Total Oil. It is from 1983. In this case, the defendant extracted hard terms in a contract with the claimant. The defendant had done this because it was reluctant to contract with the claimant. In addition, the commercial pressures upon the claimant had originated with parties other than the defendant. The court held that acceptable commercial pressures didn't amount to duress. Okay, so in these cases of economic duress, as I mentioned, we need to see it like individually, and we need to assess the four factors that the court has told to establish whether or not economic duress has occurred. Okay, so these cases of threats to the person or to the goods or the illegitimate use of pressure to force a party to contract will result in a contract which is voidable. Okay, the weaker party, the victim, must, however, act promptly to set aside the contract when the duress has been removed. Failure to do so will result in a valid contract. Okay, we have seen, like in one case that I mentioned, like the person took 8 months to bring the case before the court. So the court said there was a voidable contract, however, because of the lapse of time, the contract was valid. Okay? Let's talk about now about undue influence. Let's talk about undue influence. What do you understand by undue influence? Thank you, Bash. Yes, it's an equitable relief for when a position of influence is abused. That's correct. Undue influence is an equitable doctrine that involves one person taking advantage of a position of power over another person. In other words, it operates where the people are in a relationship such that one party relies upon the other. So here, equity focuses in the relationship between the parties to the contract. So if undue influence is proved in a contract, the contract is voidable by the innocent party, and the remedy is rescission. Undue influence has 3 categories, we can say. No, 2 categories. Actual undue influence and presumed undue influence. And we are going to see that within presumed undue influence, there are like a genuine presumption and evidentiary presumption. Okay? What do you think actual undue influence is? Let me see. Actually, latent pressure is applied. We have mentioned like undue influence is related to the relationships of the party, right? So in actual undue influence, an innocent party here, where a contract is voidable by pressure, not necessarily duress. Yes. We are going to see that here in actual undue influence, an innocent party may also seek to have a contract set aside for actual undue influence where there is no presumption of undue influence, but there is evidence that the power was unbalanced at the time of the signing of the contract. So here, the claimant, the weaker party, must prove that the wrongdoer actually exerted an undue influence upon the complainant to enter into the transaction in question. This may include, such acts as threats to end a relationship or continue to bother the party where they have been refused consent until they eventually give in. So in these cases of actual undue influence, the criteria are that the party to the transaction had the capacity to influence the other party, that he did influence the other party, that the exercise of the influence was undue, and that it was because of this influence that the transaction was brought about. Okay? It's necessary to mention that in these cases, there is not a requirement to show that the transaction was manifestly disadvantaged to the parties subject to the undue influence. Okay? So a case that illustrates actual undue influence is this case of CIBC mortgages versus Pitt. In this case, what happened is that Mr. Pitt wanted to purchase some shares on the stock market. So he pressured his wife into signing a mortgage of £150,000 securing the family home. Okay, the stated purpose of the loan was to purchase a holiday home and pay off the existing mortgage. The husband used the money to purchase shares and then use those shares as collateral to purchase more shares. For a time, the shares did very well and he was a millionaire on paper. The wife never saw any benefit from these shares as any income was always used to purchase more shares. But in 1987, the stock market crashed. So the bank sought to enforce the security under the mortgage, which at the time exceeded the value of the home. Mrs. Pitt, the wife, raised actual undue influence in defense. The court here held that it's not necessary for a claimant to demonstrate manifest disadvantage where a defense is based on actual undue influence. However, as the transaction didn't seem to the manifest disadvantage of the wife because the stated purpose of the loan was to purchase a holiday home, the bank was not put on inquiry and therefore could not fix with constructive notice. That's what the court said, okay? That the bank was not put on inquiry, so it couldn't be fixed with constructive notice. I just want to let you know what constructive notice is. Constructive notice arises where the bank is put on inquiry and fails to take reasonable steps to ensure that the transaction was entered freely without the exercise of undue influence. Okay? There is another case of actual undue influence. Here, this case, it is called Williams versus Bailey. Here, Mr. Bailey's son forged his father's signature on promissory notes and gave them to Mr. Williams. Mr. Williams threatened Mr. Bailey, the father, that he would bring criminal prosecution against his son unless he granted an equitable mortgage to get back the notes. What did the court say? The court held upheld the cancellation of the agreement on account of undue influence. Okay? Let's talk about presumed undue influence. What do you understand by presumed undue influence? Okay. In presumed undue influence, the claimant doesn't need is assumed due to the position relationship of the parties. Thank you, Jennifer. Here, the claimant doesn't need to prove that there was an actual undue influence. And presumed undue influence may arise in one of two ways. The first one is genuine presumption. Here in genuine presumption, there is a relationship of trust and confidence between the parties. So these relationships are those of fiduciary nature, such as, let's say, parent-child, doctor-patient, trustee-beneficiary, solicitor-client, religious advisor-disciple. So here, in these cases where the parties are in these relationships of trust and confidence, the law strictly protects the weaker of the parties in this relationship by establishing a presumption of undue influence. So the complainant doesn't need to prove he actually reposes trust and confidence in the other party. All what he needs to do is to establish the existence of the relationship. Also, the transaction is one which cannot readily be explained by the relationship of the parties. In other words, where the transaction is obviously not to the benefit of the vulnerable party, but confers a great advantage to the party in a fiduciary position, the law will raise a presumption that the transaction was entered as a result of some sort of abuse of the relationship. Okay? So here, like we need to see in this genuine presumption that the relations capable of giving rise to an automatic presumption of undue influence are those of fiduciary nature, okay? And the transaction is one which cannot be readily be explained by the relationships of the parties. Okay, we need to see those factors. In these cases, when the gift is a small one, the presumption will not apply. However, when the transaction is more substantial and even the vulnerable party also receives a benefit, some explanation will be needed on the part of the donee. So the court should consider the transaction as a whole. Okay? There is a case, it is called the NatWest Bank versus Morgan. In this case, the family home was subject to a mortgage for the purchase price with Abbey National, another bank, and a second charge securing a loan of the husband's business. The couple couldn't meet the payments and got into arrears. Abbey National obtained a possession order. NatWest offered a rescue package to help the couple save the home, whereby they would pay off the existing mortgages and give a bridging loan, which was to last 5 weeks for the purposes of helping the husband's business. The manager called at the couple's home in order to explain the effect of the charge and to obtain the signatures of the parties. So the manager was at the house for 20 minutes and spent 5 minutes alone with the wife. The husband was reluctant to leave them alone, but was said to be hanging around close by at all times. The manager told the wife that the charge was to pay off the existing debt and to provide a bridging loan for a period of 5 weeks, which was what the bank had intended to provide. However, the actual document didn't limit the amount or time. Mrs. Morgan told the manager that she didn't want to be exposed to any extra risk of her husband's business as she had no faith in his ability as a businessman. The manager assured her that the risks were limited in the way he had described. At no time, the manager advised her to get independent legal advice, so she signed the charge. The bank later called in the charge. In her defense, the wife stated that the bank manager had exercised undue influence over her in procuring her signature. The court held here that the normal relationship between a customer and a banker was not one so as to give rise to a relationship of trust and confidence. Okay? So in this case, the wife didn't establish a relationship of trust and confidence, and therefore, no presumption of undue influence could arise. So we need to see in these cases of genuine presumption, like the relationship of the parties. This relationship is a kind of fiduciary relationship. Evidentiary presumption. What do you understand by evidentiary presumption? Evidential presumption, in these cases, it must be established that there is a relationship of such a kind that one party, in fact, places his trust and confidence in the other one to safeguard his interests. Any relationship is capable of amounting to these examples include a husband and wife, cohabitants, employer and employee. So the complainant needs to establish the relationship and an inexplicable transaction, and then the burden of proof shifts to the other party to disprove the presumption. That the transaction is inexplicable means that the transaction is disadvantageous to the weaker party. The presence of disadvantage strengthens the presumption that the only reason for the transaction was the undue influence of the strong party. The party accused of exercising undue influence may rebut the presumption, but demonstrated that the weaker party, the vulnerable party, exercised free will in entering the transaction. This can be established by demonstrating that they were fully aware of the risk involved and had received legal advice before agreeing to the transaction. Okay? Also, within undue influence, we are going to see undue influence, and third parties. So in these cases, it occurs where the relationship of undue influence exists between spouses and one spouse induces the other one to enter into a transaction with a bank. So here the bank is the third party. The issue is whether or not the transaction with the bank will set aside because of the relationship with another party. The transaction will be set aside if the bank has actual or constructive notice of the possibility of undue influence. So we have said that a constructive notice arises where the bank is put on inquiry and fails to take reasonable steps to ensure that the transaction was entered freely without the exercise of undue influence. So there is this case, the Royal Bank of Scotland versus Etheridge. In this case, the House of Lords carefully outlined the steps a financial institution must take to avoid taking a charge with notice of the service claim to set it aside. I recommend you to read this case because the House of Lords, suggests to the financial institutions what they should do to meet this requirement of constructive notice. So, do you have any question? Or can I ask you questions? Of this last case, it is called the Royal Bank of Scotland versus Etheridge. Etheridge is spelled E-T as Thomas, R-I-D-G-E. The case is known as RBS versus Etheridge. So let me ask you some questions. What is the effect of duress? Exactly, we share the contract. So when duress happens, let's say like in a contract, duress has happened. What are the important consequences? What does the party subject to duress needs to do in order to set aside the contract? Do you remember? Act promptly, yes. Rescind a tap, exactly. Because if not, lapse of time, the court license, okay, this party has affirmed the contract and the contract is valid. In duress to goods, what does the court say about duress to goods? Yes, can be used for restitution. Good. The law of restitution. Exactly. Thank you. And in economic duress, what is difficult like to prove in why is difficult to prove in an economic duress case? Do you remember? You know, like we need to distinguish between acceptable commercial pressures and unacceptable commercial pressures, but we need to see every case. So we need to see the facts of the case and decide whether or not economic duress has arisen. That's what the court have the court has suggested. And there are 4 factors that we need to consider. Did the person claiming to be coerced protest? Did that person have any other available course of action? Was that person independently advised? And after entering into the contract, did the person take steps to avoid it? So those are the 4 factors that we need to see to establish whether or not economic duress has happened. Okay. What do we need in under within presumed undue influence to establish a genuine presumption? What do we need here? What is important in a genuine presumption case? How does the relationship need to be? It needs to be a fiduciary relationship, a relationship of trust and confidence, and that the explanation for the transaction is this relationship, okay? This is in genuine presumption. And in evidential presumption, what we need to see in evidential presumption? In these cases, we need to establish that there is a relationship where one party, in fact, places his trust and confidence in the other one to safeguard their interests. This could be, for instance, a husband and wife, employer and employee. Okay, and here the burden of proof, once the complainant has established a relationship and the transaction, the burden of proof shifts to the other party to disprove the presumption. Okay? So thank you so much for your attention. And, you know, if you have any questions, let me know through Ms. Akram, please. Thank you so much. It was a pleasure. Have a good weekend. Bye.
Ms. Kutera, are you still there?
Sammy. Sammy.
Hey, Bash.
Did you see I just made a new word?
You said what?
I just made a new word. I don't know what happened to my keyboard, but I typed, what is it?
I can hardly hear you, Bash.
Hold on.
Hello?
Sorry, I'm coming. I'm responding to someone.
Oh, okay.